So Hugo asked me to discuss the viability of pursuing litigation in the United States court system in order to resolve the de-risking epidemic. And the first bit of advice that I gave to the audience was to avoid litigation if possible and pursue other remedies such as lobbying and government relations and other things like that that will allow companies to avoid litigation, because litigation can be very, very expensive and the likelihood of success is totally unknown. But if the companies or a group of companies or the MSBA or some other organization like that believes that litigation is unavoidable and they have to pursue a lawsuit in a United States district court somewhere, the recommendation that I made, rather than focusing on the bank account or the loss of the bank account itself, is to focus on the fact that their due process rights have been violated. And what that means in this environment is that in certain circumstances, banks have been forced to close accounts. The instructions have been coming from the federal government, whether it's the NCUA or the FDIC or the IRS or some other regulator. And in certain circumstances, that might turn the bank into a government actor. And as a result of that, the money transmitters which are losing that accounts might be entitled to certain due process rights. And to the extent that they haven't been provided with adequate notice or the opportunity to be heard, and they don't know what the rules are regarding how to maintain a bank account or what the bank or the government might be looking for because the standards have never been promulgated, well, that might be something that's actionable in a United States district court. But I encourage the audience to make very clear, as you know, early on in the process, that litigation is unavoidable, that they have no other options, and then when they make that decision, to be very strategic regarding how to pursue that litigation, including making sure that the right plaintiff is in court and that they're suing the right defendant and that the cause of action is properly submitted to the court so that we make sure that the court actually has the subject matter jurisdiction that it needs in order to hear the dispute. Because doing any of those things wrong can result in a lot of wasted time and energy, and ultimately it can result in the companies really starting from scratch, no longer having the option of going into court. So the decision making needs to be very, very sharp and precise, and again, it's not a decision that somebody should make lightly. 2017 is going to bring about a brand new government administration, which very well may have a different perspective as it relates to remittances. Donald Trump, as a presidential candidate, had on his website a plan for building the wall between Texas and Mexico that involved requiring money transmitting business customers in the United States to be able to prove that they're lawfully here before being allowed to send money out of the country. Now, whether that actually becomes the policy of the administration, I don't know yet, but at a minimum, it makes clear that this industry needs to stick together, needs to understand what's happening with the administration, needs to get information in real time so that they can make proactive decisions as opposed to reactive decisions, and that they're able to have their voices heard and participate in the process. It's never been more critical as it is now.